Imagine being picked up by ICE and told you're being deported. But not to your home country, but to a place you've never been before, a country where you don't speak the language, a country torn apart by war, and worst of all, you don't even get to argue your case in front of a judge before you're shipped off. This week, in a stunning shadow docket decision, the Supreme Court gave the green light for the US to deport people to a third country, even while serious legal questions are still being litigated. And there was literally a plane waiting in Djibouti with detainees and customs officers on board while this played out in real time. And if you think this sounds like a due process nightmare, you're not wrong. And what makes this even worse is that the Trump administration openly flouted 2 district court orders not to remove people to South Sudan. And right or wrong, rather than backing up the district court judge who issued the orders, the Supreme Court basically told the Trump administration, hey, it's totally cool that you ignored the orders.
Thank you again. Thank you again. Won't forget. So good.
And they did this all on the shadow docket without writing a single word about why they allowed the government to proceed. So today we're going to break down what Georgetown law professor Steve Vladeck calls a disastrous Supreme Court decision, and if that man says it's disastrous, this is an actual 5-alarm fire, and explain what it means for immigration law, due process, and the limits of executive power. Now, on February 18, 2025, the Department of Homeland Security issued a policy directive instructing officers to review all cases of individuals previously released from immigration detention for redetention and removal to a third country, a country that differs from the countries of origin or citizenship. Now, a class of non-citizens with final removal orders sued DHS, challenging the government's practice of removing people to a third country without providing notice or opportunity to contest. Now, make no mistake, under 8 U.S.C. 1231, the government is allowed to remove individuals to several specified countries, such as their country of birth, last residence, or departure port. If none of those countries are viable, the statute allows the government to send the person to any country willing to accept them. Now, this class action did not challenge the government's right to remove people to third countries. The core issue was whether people facing removal to a third country have the right to notice and a chance to object if they fear torture or inhumane treatment to this country that they've probably never been to. These protections are known as cat relief under the Convention Against Torture. Non-citizens already have the right when the destination is the country originally named in the case. In other words, everyone agrees that when deportation proceedings begin and the government names the place that the non-citizen is intended to be deported to, that non-citizen has the right under immigration law to contest in front of an immigration judge the location of their deportation. Because it's often the case, especially with asylum seekers or refugees, that really terrible things could happen if they're deported to a specific country. But the question here was if that same protection applies when the government picks a different country after the removal proceedings are already over. And here, the district court judge, Brian Murphy, concluded that it does. He issued an injunction stating, quote, "The case presents a simple question. Before the United States forcibly sends someone to a country other than their country of origin, must that person be told where they are going and be given a chance to tell the United States that they might be killed if sent there? Defendants argue that the United States may send a deportable alien to a country not of their origin, not where an immigration judge has ordered, where they may be immediately tortured and killed without providing that person any opportunity to tell the deporting authorities that they face grave danger or death because of such a deportation. All 9 sitting justices of the Supreme Court of the United States, the Assistant Solicitor General of the United States, Congress, common sense, basic decency, and this court all disagree. Plaintiffs are seeking a limited and measurable remedy. One defendants have conceded in other proceedings is the minimum that comports with due process. Plaintiffs are simply asking to be told they're going to be deported to a new country before they are taken to such a country and be given an opportunity to explain why such a deportation will likely result in their persecution, torture, and/or death. This small modicum of process is mandated by the Constitution of the United States, and for this reason, the motion for class certification is granted, and the motion for preliminary injunction is granted in part. Now, despite that common sense decision from the district court, unfortunately only 3 Supreme Court justices agree that before the government deports someone to a new country where they may face torture, enslavement, or death, that person is entitled to notice and a hearing. And the majority made its decision on the shadow docket. The shadow docket refers to the Supreme Court's use of emergency orders and summary decisions that are issued without full briefing, oral argument, or signed opinions. And the Roberts Court has used the shadow docket more than any court in history. They have used it to make highly consequential decisions without full transparency. Now, this all gets a little bit technical, but at least 5 justices granted the government's request to lift Judge Murphy's stay. So in other words, what happened here is the district court, the trial court, issued this preliminary injunction temporarily preventing the government from removing these people without notice. Then the government appealed, and as part of that appeals process, sought to lift the preliminary injunction while things were being appealed to the Court of Appeals and eventually the Supreme Court. And the Supreme Court said, yes, while all of this is being appealed, that preliminary injunction is invalidated, which is usually a sign of what the Supreme Court would hold on the merits when it reaches them. And because of how the shadow docket works, we don't know if any of the Republican justices privately dissented, but declined to join the dissenting opinion. And in this case, the majority chose not to reveal their reasons for granting the stay of the preliminary injunction. The block paragraph simply says that the preliminary injunction is stayed, meaning it's not a final ruling on the merits. In effect, however, the order allows the Trump administration to deport anyone with a removal order to any country it chooses, regardless of the potential dangers, and without giving that person a chance to challenge that decision. Now, unlike the government, if you kidnap people and send them to a third country, you're going to want a good lawyer. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've gotten in a car crash, suffered a data breach, especially if you got one of those data breach letters saying that your information might have been leaked, or dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you understand your legal team, you need the Eagle Team. Now, Justice Sotomayor, writing for the 3 liberal justices, blasted the decision in a 19-page dissenting opinion. She started by reviewing the government's actions in this case, which included ignoring direct court orders. Quote, here, in violation of an unambiguous TRO, the government flew 4 non-citizens to Guantanamo Bay and from there deported them to El Salvador. Then, in violation of the very preliminary injunction from which it now seeks relief, the government removed 6 class members to South Sudan with less than 16 hours notice and no opportunity to be heard. The government's assertion that these deportations could be reconciled with the injunction is wholly without merit. Notice at 5:45 p.m. for a 9:35 a.m. deportation provided to a detainee without access to an attorney plainly does not afford that non-citizen with a reasonable time to seek relief. Even if the government's overnight notice had been adequate, moreover, DHS also did not provide the required meaningful opportunity to raise a fear of return under the convention. The affected class members lacked any opportunity to research South Sudan to determine whether they would face risks of torture or death there or speak to anyone about their concerns. Instead, they were left in their cells overnight with no chance to raise a claim and deported the next morning. The government thus openly flouted 2 court orders, including the one from which it now seeks relief. Even if the orders in question had been mistaken, the government had a duty to obey them until they were reversed by orderly and proper proceedings. That principle is a bedrock of rule of law. The government's misconduct threatens it to its core. And the majority has now sanctified the government's gross misconduct. Justice Sotomayor says this decision erodes the rule of law. Quote, this is not the first time the court closes its eyes to noncompliance, nor I fear will it be the last. Yet each time this court rewards noncompliance with discretionary relief, it further erodes the respect for courts and for the rule of law. And she's right. All this deals with courts of equity, which I will simplify by saying non-monetary relief. This court issued an injunction that is an equitable remedy. And there's a saying that in order to receive equity, you must do equity. And here the government has engaged in manifest bad faith, ignoring court orders, and it's shocking that they can get away with their unclean hands. And one of the most troubling elements of the court's decision is the way it undermines the authority of district court judges. District courts are responsible for conducting thorough fact-finding, a responsibility that appellate courts have traditionally respected and deferred to. And time after time, even Trump-appointed judges have found against the administration after conducting thorough hearings. But the Roberts Court showed open disregard for the district court's work. As the dissent puts it, quote, in matters of life and death, it's best to proceed with caution. In this case, the government took the opposite approach. It wrongfully deported 1 plaintiff to Guatemala, even though an immigration judge found he was likely to face torture there. Then, in clear violation of a court order, it deported 6 more people to South Sudan, a nation the State Department considers too unsafe for all but its most critical personnel. An attentive district court's timely intervention only narrowly prevented a 3rd set of unlawful removals to Libya. Rather than allowing our lower court colleagues to manage this high-stakes litigation with the care and attention it plainly requires, this court now intervenes to grant the government emergency relief from an order it has repeatedly defied. I cannot join so gross an abuse of the court's equitable discretion. Justice Sotomayor also noted a troubling pattern in the way Republican justices are interpreting irreparable harm. In federal court, as we've talked about a lot of times, to obtain a preliminary injunction, a party must typically demonstrate 4 factors: a likelihood of success on the merits, a likelihood of irreparable harm if the injunction is not granted, said that the balance of the equities favors granting the injunction, and that an injunction is in the public interest. And the balance of equities requires the court to weigh the potential harm the moving party would suffer without the injunction against the harm the opposing party would face if the injunction is granted. And this ensures that the court only grants relief when it is fair and just to do so, preventing unnecessary or disproportionate harm on either side during the litigation. And Justice Sotomayor accused the majority of ignoring the concept of irreparable harm. Quote, "In light of the government's flagrantly unlawful conduct, today's decision might suggest the government faces extraordinary harms. Yet, even that is not the case. Rather, following a recent trend, the court appears to give no serious consideration to the irreparable harm factor. Without a showing that a stay is necessary to avoid irreparable harm, however, this court's midstream intervention is inexcusable. Besides the facially absurd contention that the executive is irreparably harmed by any time the court orders it temporarily to refrain from doing something it would like to do, the government has identified no irreparable harm from the challenged preliminary injunction. Instead, the government locates the source of its injury in the district court's efforts to provide relief to class members in South Sudan. That argument is misguided. First, the district court remedial orders are not properly before this court because the government has not appealed them nor sought a stay pending a forthcoming appeal. Second, the court adopted the narrowest possible remedy, allowing the government itself to choose whether it would return the class members to the United States or provide them with process where they are held. Finally, the government is in every respect responsible for any resulting harms. Had it complied with the preliminary injunction, no follow-up orders would have been necessary, nor would the government have faced a sudden need to detain criminal aliens abroad. It does not face such a need today, as it can return the non-citizens it wrongfully removed at any time. No litigant, even the government, may satisfy the irreparable harm requirement if the harm complained of is self-inflicted. Sotomayor also accurately pointed out, quote, "Given its conduct in these proceedings, the government's posture resembles that of an arsonist who calls 911 to report firefighters for violating a local noise ordinance." And the court obviously interpreted the balance of equities to favor the Trump administration, even though they have all the power and the migrants are the ones who are subject to removal orders that could face death. Justice Sotomayor does not mince words about the consequences of the court's decision. Quote, "For their part, the plaintiffs in this case face extraordinary harms from even a temporary grant of relief to the government. The government has made clear in word and deed that it feels itself unconstrained by law, free to deport anyone anywhere without notice or an opportunity to be heard. The episodes of noncompliance in this very case illustrate the risks. 13 non-citizens narrowly escaped being the target of extraordinary violence in Libya. OCG spent months in hiding in Guatemala. Others faced release in South Sudan, which the State Department says is in the midst of armed conflict between ethnic groups. Only the district court's careful attention to this case prevented worse outcomes. Yet today, the court obstructs those proceedings, exposing thousands to risk of torture or death. And this is why the decision is so disturbing. Although the case will continue to plod through the courts until the Supreme Court makes a final decision on the merits, the stay means that Trump has the green light to send people to nations which practice slavery and torture. And somehow at least 5 justices believe that the balance of equities favors the Trump administration. But how could that possibly be the case? How is the government harmed if they can't deport people to foreign gulags without a hearing or minimal notice? This case isn't about the authority to remove people to third countries. The government does have that power under certain circumstances. It's simply about whether putative deportees have the right to notice of where they're going and an opportunity to contest that location, which are almost certainly rights that they have under current immigration law. But we don't know what the majority is thinking on this. They made a decision that may alter the lives of thousands of people, but they chose not to explain the reasons why, which is one of the most dangerous things about the shadow docket. And Justice Sotomayor expressed extreme concern that her colleagues are enabling the total destruction of the rule of law. Quote, "The Due Process Clause represents the principle that ours is a government of laws, not of men, and that we submit ourselves to rulers only if under rules. By rewarding lawlessness, this court once again undermines that foundational principle. Apparently, the court finds the idea that thousands will suffer violence in far-flung locales more palatable than the remote possibility that a district court exceeded its remedial powers when it ordered the government to provide notice and process to which the plaintiffs are constitutionally and statutorily entitled. That use of discretion is as incomprehensible as it is inexcusable. Respectfully, but regretfully, I dissent." And the impact of this ruling is honestly huge. It allows one of the government's draconian deportation schemes to move forward without delay. Now, during the Biden administration, the U.S. allowed about 1 million people to enter the country legally for humanitarian reasons. But the Supreme Court let Trump end the Cuban, Haitian, Nicaraguan, and Venezuelan humanitarian parole programs. And as a result, nearly 500,000 people must leave the country or face removal. And while that program existed, all of those people were in this country legally. And the court also allowed Trump to end protected status for around 500,000 Venezuelan nationals. In both of these cases, the court Court granted the administration a stay of lower court orders, halting the administration's efforts. Now those people can be placed in removal proceedings. But what's crazy is because of this particular ruling, they're in even greater peril. If an immigration court rules that they can't be removed to their country of origin, which they left because of a humanitarian disaster, the Trump administration could send them basically anywhere it wants to. South Sudan, Libya, El Salvador, or any third country, all without any notice or process whatsoever. And while the Supreme Court has been making these rulings on the shadow docket, lower court judges have been ordering the administration to return individuals who were deported in violation of court orders or deported in error. But now the Justice Department has no incentive to follow lower court orders, and the government is incentivized to just quickly send people wherever it can across the globe as quickly as it can. But regardless of your naturalization status, now is probably a good time to wipe the internet of all of your personal data. And this can literally be the difference between life and death. And it's not surprising. These data brokers vacuum up all your personal data from all corners of the internet and sell it to anyone who wants to buy it. But you can fight back and take control of your sensitive data from data brokers with the help of today's sponsor, Incogni. Because Incogni removes your personal data from online data brokers by reaching out directly and forcing them to take your personal info down. If these data brokers resist, Incogni will take care of that too because Incogni fights back. Now, Incogni scours the internet by itself, but they just launched a new feature called Custom Removals. If you find something else, it allows you to flag an unlimited number of sites where your data might be exposed, and you can have Incogni's privacy experts review and tackle the most uncooperative data brokers and people's search sites. But these data brokers are the reason why in the US you can search your name and find a bunch of websites that'll give anyone your home address, phone number, and extensive history. It's shocking just how easy it is to find all this information. It also might be why you're getting so many spam calls lately, or even how someone might steal your identity. But Incogni is a great way to take back control of your data, increase online privacy, and cut down on those annoying scam calls and emails that used to flood my voicemail and inbox. Now, I've been using Incogni for years, and in that time you can see that I've been on hundreds of lists, some of which had a high sensitivity score, meaning the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me over the years and is processing dozens of others. If I were to try this myself, it would take hundreds of hours. So thank you to Incogni for saving me weeks of free time and adding me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals because even if the broker removes your data once, they can collect it again. And Incogni makes sure that your personal information stays off the market for good. So if online privacy is important to you, give Incogni a try. So if you click on the link that's on screen or down below, you can try Incogni risk-free for 30 days or get a full refund if you're not into it. And if you do decide to keep it, you'll still get the exclusive 60% off discount so long as you use my link or the code LegalEagle, all one word, at checkout. So after you sign up for Incogni, click over here for more LegalEagle, or I'll see you in court.